Thank you, Mr. Chair. AB 2261 will strengthen California's critical employment retaliation provisions by authorizing the Labor Commissioner to independently cite and employ an employer for retaliation. Currently, an employee must come forward and file a claim with the Labor Commissioner. This can be particularly a particular barrier in the retaliation cases, since the employee complaint model forces an employee who has already been retaliated against to come forward and individually complain, risking further retaliation by the employer. Opponents have raised concerns that this bill would change the standards, processes, or statutes of limitations for these retaliation claims. In order to address those concerns, we have amended the language of this bill into Labor Code Section 98.7 to clarify that this bill only will the Labor Commissioner This bill will only allow the Labor Commissioner to issue citations for retaliation under the same rules and with the same due process rights as currently exist for employee complaints. We are continuing to discuss any further concerns from the opposition and remain very hopeful that we can continue moving this bill forward, working with all stakeholders. I respectfully ask for your aye vote.
Great, thank you. Witnesses support.
Mr. Chair, members, Michael Young on behalf of the California Labor Federation, sponsors of the bill. First, I want to thank the author for bringing this measure and thank this body for one. You guys have done tremendous work over the last few years to expand retaliation protections for workers. And as a result of those expanded protections, we've seen the number of retaliation claims increase since 2011. We believe that those claims have gone up about 48%, increasing at about a rate of 16% each year. That being the case, we believe this bill will give the Labor Commissioner additional tools necessary to adjudicate and close those claims more swiftly. They'll be in line with the policies and procedures that are already in place at the Labor Commissioner's office for various other claims dealing with overtime protections, meal and rest period violations. In those instances, she's allowed to investigate and cite directly, and we see fast and swift endings to those claims. And we believe that applying that to retaliation is the right and prudent thing to do. So with that, we urge your aye vote. Thank you.
Thank you. Any other witnesses in support? Please step forward.
Gina De Silva with the California Immigrant Policy Center in strong support.
Thank you.
Rene Bayardo, SEIU, California, also in support.
Thank you. Okay. Any witness? You have the opposition step forward, please.
Good morning, Mr. Chair and committee members. Jennifer Barrera on behalf of the California Chamber of Commerce. And we are currently opposed to the bill, though we do appreciate the author's recent amendments to address the statute of limitations issue. Our main outstanding concern is just the ability for the Bureau of Field Enforcement, the Labor Commissioner's Office, to conduct a random investigation for retaliation under this bill without any indication, employee complaint, any facts to justify an investigation and subjecting employers to these random investigations audits. Under which there's no issue that has arisen to the Labor Commissioner's office. I appreciate that the Labor Commissioner we have right now is fantastic and has done a great job at doing targeted investigations when there are facts to support such it, but we're concerned obviously with the later impact of other administration commissioners that may not have that same attitude towards targeted investigations. Our proposal is to allow the Bureau of Field Enforcement, when they're already conducting an investigation with the current authority they have for wage and hour issues such as meal and rest period violations, minimum wage violations, if there's facts that indicate there has been an instance of the retaliation, to report that to the Labor Commissioner's office, who currently handles those retaliation investigations, and allow them to pursue a retaliation investigation through the normal procedures that already exist under Labor Code 98.7. We believe that addresses the issue of having an employee not have to go forward and issue a complaint, and allows the Bureau of Field Enforcement, when they're already out in the field investigating a wage and hour violation, to report that to the Labor Commissioner's office, who handles the investigation. We're working with the author, working with the sponsor to try and work out that compromise, and hopefully we'll get there. With that, we remain opposed until that's addressed. Thank you.
Thank you, Mr. Chair and members. Jason Schmelzer here on behalf of CSAC Excess Insurance Authority, and there is little chance that I'm going to add in any way to what Ms. Barrera just said as a practicing labor attorney, so I'm just going to associate myself with their comments and move on. Thank you.
Great. Thank you so much. Any other witnesses in opposition?
Javier Gonzalez with the California Restaurant Association would like to align our comments with Ms. Barrera and the Cal Chamber. Thank you.
Thank you, Javier. All right. Any others in opposition? Okay, great. We'll bring it back to the committee. Any members, senators, want to say a few words? Senator Jackson?
Yes. I appreciate the issues and the articulation of opposition by the opponents here. I'm going to move the bill. with the understanding the bill's going to come to Senate Judiciary next, and I'll be very interested to see how these discussions move forward in the interim. So I'd like to move the bill.
Great. The bill has been moved. Senator Leno?
Question. If you have any response to Ms. Barrera's comments, astute comments.
Yes, absolutely. I think it's just, current statute is not enough. Today, if the labor commissioner observes a violation of the law, she can't cite. The law is very clear. It has to be reported by the employee, the affected party. I would liken the current law as if a CHP officer witnessed a motorist drive right through a red light and commit a collision, unlawful, running of the red light, and had no power to cite, even though they witnessed it. That's the current state of affairs for the labor commissioner when visiting and doing these targeted visits to enforce law. So this is just about making sure that our labor commissioner is able to actualize the powers that we think resides with her office and department. So with that, with these changes proposed here today, we ask for that correction. Thank you.
Okay, seeing no other comments, we do have a motion. I want to thank the author for bringing this bill forward, very important, and I want to ask for a roll call. Madam Secretary, please call the roll.
The motion is due pass to judiciary. Mendoza?
Aye.
Mendoza, I. Stone? No. Stone, no. Jackson? Aye. Jackson, I. Leno?
Aye.
Leno, I. Mitchell? Aye. Mitchell, aye.
Bill has 4 votes. It is out. Do you have one more? Okay. Item number 12, AB 2895.
Yes, thank you, Mr. Chair and Senators. This bill, AB 2895, will ensure that workers in California have access to important workplace safety information. In the winter, my Labor Committee convened a hearing exploring the high rate of workplace fatalities and injuries of Latino workers. That hearing made it very clear that many workers lack even the basic understanding of workplace health and safety issues and programs available to them. Under current law, employers are already required to establish written injury and illness prevention plans, IPPs. All this bill does is ensure that workers are provided with access to this important legally required information. It is my hope that this will enable workers to be aware of some of these issues and the employer's process and procedures for dealing with workplace safety issues. We have taken several set of amendments to address opposition concerns, most notably by eliminating the $750 civil penalty and instead providing for injunctive relief. We will continue to work with the opposition, and we respectfully request your aye vote.
Great.
Mr. Chairman and members, Mark Schacht with California Rural Legal Assistance Foundation, sponsors of the bill. This bill is modeled after 2 existing statutes and 1 regulation that deal with wage records, personnel records, and health and safety records. Just distributed to you a copy of the existing regulation promulgated by the Division of Occupational Safety, and which went into effect last summer, which requires that each employer shall establish, implement, and maintain an effective heat illness prevention plan. And this is the key point. The plan shall be in writing in both English and a language understood by a majority of the employees, and shall be made available at the worksite to employees and representatives of the division. This is a forward-looking response by DOSH to the fact that nearly 40% of all California households speak a language other than English. And if you look at more data from the the Bureau of the Census, it indicates that roughly 40% of Spanish speakers don't speak English well. So we're asking the legislature to go 1 step farther to require that the Illness and Injury Prevention Program, which is the bedrock for best practices and health and safety in California, and to require that to be at each work site in a language understood by the workers, and that a copy be given to the worker on written request. The other models for this statute, and I'll just wrap this up quickly, the Assembly member mentioned dropping the $750 penalty. The Personnel Record Statute and the Wage Record Statute had 2 provisions. One, a $750 penalty for a violation, and injunctive relief, and attorney's fees. What we did when we dropped the $750 penalty is we were faced with the non-enforceability of this requirement. And so we did two things that were different from existing law. The first thing we did is make a citation by the division the default enforcement mechanism of this requirement. If and only if the department hasn't cited, may an employee seek to compel compliance in a court. The second major difference is that in existing law, a single written request is sufficient, if ignored, to go to court and utilize the injunctive powers under the Act. This statute, and this is an amendment that went into effect in just the most recent set, requires two lawful written requests by the employer to be ignored with the absence of a citation by the division before a worker can enforce his right or her right to get a copy of the IIPP. For those reasons, we urge your support for the bill, and I'd be happy to answer any questions.
Great, thank you. Any other witnesses in support? Please step forward.
Thank you, Mr. Chair and members. Renee Bayardo, SEIU, California, also in support.
Thank you.
Thank you, Mr. Chair and members of the committee. Jeremy Smith here on behalf of the State Building and Construction Trades Council, also in support.
Thank you.
Mr. Chair and members, Caitlin Vega for the California Labor Federation, also here in support.
Great, thank you. Any other witnesses in support? Any, the opposition, please step forward.
Good morning. Marty Fisher here on behalf of the California Chamber of Commerce, as well as our employer coalition. And we are in opposition to the bill. We're not opposed to having employees have access to the IIPP. As a matter of fact, many of our employers do provide access. However, the IIPP, keep in mind, it's not intended to provide information to the employee. It's a roadmap for the employers and how they intend to meet its requirements, and how they plan to provide the appropriate information and training to the employees. It's also so that employers and Cal OSHA can see that the employer is implementing their policy the way that they have it written. That's why the current law doesn't require the IIPP to be written in multiple languages. It's not really intended for the employees to be using that for their safety information. It's for the employers to tell them and to tell their supervisors how they're going to implement their plan. The requirement to maintain a copy of the IIPP at every work site is vague and unnecessary. What is considered a work site? Is that every job site truck? What about remote employees? If it's a residential home construction, is it one in every house? We believe that providing access for review upon request should be sufficient, not necessarily having a copy right there. The requirement to inform employees separately of their rights under this bill is overly burdensome, creates a new requirement and liability for employers. It seems it would be sufficient to inform employees of their right to access the IIPP during their normal IIP training, when they're providing a variety of communication to them, and this is required under the law now, that they have training in accordance with what the safety practices are for the work site and for their specific job duties. This just creates, the way the bill is written, it creates a new notification requirement that creates a new liability, a new opportunity to be in violation when there's already an appropriate safety communication system in place. Furthermore, Cal OSHA enforces all the Cal OSHA regulations and has a penalty scheme for violations. PAGA allows employees to pursue civil penalties through the legal system when agencies don't have the resources to do so. A violation of this provision in this bill doesn't create a harm to employees, so there's no reason to implement a new enforcement scheme by involving the court system for such a minor paperwork violation. There's no reason that an employer or their authorized representative, which it seems to be intended to be their attorney, should need a written copy of their own of the IIPP unless there's a lawsuit, and at that time, normal discovery procedures should be followed. For these reasons and others, we remain opposed. Thank you.
Thank you.
Good morning, Mr. Chairman, Senators. Julianne Broyles here on behalf of both the Family Business Association of California and Associated Builders and Contractors of California in opposition to Mr. Hernandez's bill. I've worked on the IIPP issues for going on 25, almost 30 years, since 1993, when the first, 1992, and effective 1993, when the first SB 198 went into play. It has been a long and often discussed issue where this is a as Ms. Fisher pointed out, it is a communications plan for the employer to follow to communicate to their employees how to be safe in that particular work site. It's elastic enough to ensure that when new equipment is brought in, new procedures are instituted, training is renewed. But it is really to tell Cal OSHA how you're making your workplace safe. Today in this bill, unfortunately, we're trying to go beyond that and say there's going to be additional enforcement beyond Cal OSHA and let the employee go to court to seek conjunctive relief. And if my recollection of the civil code, I'm not an attorney, but it is that if you're applying for injunctive relief, the court looks at the issue as not valid unless there is some kind of recompense to the person bringing the injunction. So that would be a new expense, and we'd be going into Superior Court to adjudicate this when I know for a fact that it is already a highly impacted system for resolution. Employers pay for Cal OSHA to enforce the law. This would be an additional cost onto them and an additional burden in reporting on those employers. We would ask for your no vote at this time. We're happy to talk with the author and the committee about further resolution on this, but at this point we must oppose.
Thank you. Others in opposition?
Brian Little with the California Farm Bureau Federation. I'd like to associate myself with Ms. Fisher's and Ms. Broyles' remarks. Thank you.
Thank you.
Nicole Rice, California Manufacturers and Technology Association, also opposed, and just wanted to raise the point that while we appreciate the changes that were made to the penalty section of the bill, it still also leaves open the question of who is going to actually determine that a claim isn't being made by an individual until after Cal OSHA actually cites, or whether or not there actually has been two written requests made in order for a claim to go forward. So those are some other issues, as well as those that were raised by others in opposition, that we still have concerns with, and for that reason we're opposed.
Thank you. Any others in opposition? Bring forward a note, Mr. The author, if we could, I know there was a few issues that were being brought up, and from the opposition saying that this plan is basically not meant for employees, it's meant for the supervisor of the company just to show a plan of what they're doing. They've said that as far as their opposition. How would you respond to that?
I would very much appreciate the opportunity to respond. This bill is 100% centered on addressing employee injuries and deaths in the workplace. As I mentioned earlier, last fall I conducted a hearing in downtown Los Angeles looking at fatalities and injuries in the workplace. And what we found that for most workers in America, in California, injuries in the workplace had declined except for one group, Latino workers. Latino workers' death, mortality, injuries had actually gone up. And the second group on ethnic analysis was African Americans. So Latinos and African Americans are more likely to be injured or killed in the workplace. And the driving reason from those that were testifying in our hearing was that they just didn't know what programs and opportunities existed to ensure greater safety in the workplace. Many of them, there was language barriers. For many of them, the information was not accessible to them. So what became really clear after hearing from workers up and down the state of California, labor leaders who have had experience with dealing with these matters, it was about getting more information directly to the worker, making sure that the worker was aware of programs, workers' rights in addressing work safety issues. So this IIP requirement in the law is significant, and it was said by one of the representatives in opposition that the violation of this law doesn't hurt workers. Well, I would respectfully beg to differ. We have found that when workers don't know, they're more apt to being injured. We know that the incidents at LAX with the Menzies workers not being informed of current labor law and protections allowed for many fatalities and injuries in the workplace, and we saw the same with BART workers in the Bay Area. So we think this is an important piece of legislation to just get more information, leading to more empowerment in the minds of the workers and in their own knowledge. But we've worked with the opposition. We had a $750 civil penalty fee that was not a number that was unilateral. It was a number that was consistent with penalties in the similar labor area with regards to prohibiting or restricting information regarding payroll and work records, employee personnel records. There's a $750 fine there. Here what we're saying is we've removed the $750 fee that we're proposing. We're saying that this matter will only be eligible for injunctive relief after an employee has provided their employer 2 written notices requesting information that is already required by law to be provided to his employees. Most of the workers that I've had a chance to come across that are most likely to find themselves in dangerous workplace conditions for lack of information don't necessarily bring the written and oral skills to bring this information. So this bill is not an easy pathway, but it's a step in the right direction, I believe, to getting workers more information. And I hope, and I believe the labor advocates hope, that they will use this legislation to get that information more readily to workers. So yes, we want to combat that, the current reality that workers are still being hurt in the workplace, much of it driven by lack of information.
Okay, thank you. I'm going to bring that to the committee. Any questions or comments from the committee members? The bill has been moved. Seeing that there is no other comment, I would like to say, Member Hernandez, go ahead and close it.
I respectfully ask for an aye vote.
Thank you. Madam Secretary, the motion, please call the roll.
The motion is due pass to appropriations. Mendoza?
Aye.
Mendoza, aye. Stone?
No.
Stone, no. Jackson? Aye. Jackson, aye. Leno?
Aye.
Leno, aye. Mitchell? Aye. Mitchell, aye. That's 4 votes.
Okay, go ahead and vote. 4 votes, it is out. Based on our sign-in sheet, the next member is Senate Member Thurman.